What we know is a drop. What we don't know is the ocean.
Hello, and welcome to the Newton Knowledge Podcast. My name is Mark Singer, partner of Newton One Advisors, and I'm joined by our managing partner, Steve Target. The Newton Knowledge Podcast will provide meaningful content to our valued advisor community. Our discussions will deliver unique insights into the people, processes, and products that make our industry so critical. Newton One is a national life insurance planning firm delivering customized solutions structured to help clients and their advisors engaged in solving estate planning, wealth transfer, business succession, and executive benefits challenges. We are a member of the M Financial Group, which grants our clients access to the nation's elite carriers and exclusive products available only through our network. Today we're with Bradley Terebelo, partner at Heckscher, Teillon, Terrill, and Sager. How was that?
That was perfect.
Beautiful. Thanks for being with us today, and thanks for having us in your beautiful office. I was telling Steve how nice the lobby is, and I checked out the gym as well. It's really cool.
It is a nice gym, yeah.
Brad's practice involves all aspects of trust and estate planning and administration, focusing extensively on trust administration and fiduciary litigation. He has spoken and written on issues concerning trust modification and change of situs. He presented at the Pennsylvania Supreme Court Orphans Court Ruling Committee concerning representation of minor, unborn, and unascertained beneficiaries in trust proceedings. He served as a chair of the litigation committee of the Philadelphia Bar Association's Probate and Trust Law section, and currently is co-chair of the committee. Brad is also a former member of the executive committee of the section and was former chair of that section's legislative committee. He is a fellow of the American College and Trust Estate Council, or ACTEC. In 2019, Brad was named a lawyer on the fast track by the Legal Intelligencer as part of the publication's annual Professional Excellence Awards. So our discussions today will be in reference to the article co-written by Brad and his partner Margaret Sager, titled Down the Rabbit Hole and Through the Looking Glass, the Wonderland of Trust Situs and Governing Law. To kick it off, can you explain what trust situs is and why it is important in the realm of trust management, Brad?
Sure. Thanks, Mark, and thank you again for Mark and Steve for both having me here. Trust situs, you'll hear also referred to as the principal place of administration. And what people think about trust situs is basically it's where are you administering your trust? And that can have all kinds of implications. It has tax implications. Where is a trust taxed for income tax purposes? Because trusts are their own taxpayer. Where do you go to court if there's an issue that you need resolved either in litigation or otherwise? What laws apply? That can have an impact depending on where the situs is.
What are some of maybe the key advantages of moving a trust situs to a new jurisdiction? And I guess before you even answer that, can you move a trust situs?
You can move a trust situs, and that is a lot of what my practice is, and also my partner Margaret Sager that Mark you mentioned earlier, is that you can change situs. There are lots of reasons why you might want to. One of the most traditional ways is, especially as we become a more mobile society, is, well, Dad created this trust in Pennsylvania, but we all live in Florida. Why are we having to come up to Pennsylvania to deal with this trust? Wouldn't it be easier if we could go to our trustee down the road, go to court down in Florida and deal with things down there? Why do we have to come up to Pennsylvania for that?
Yeah, and you'd be in Florida.
So I was going to say it's pretty hot down there. It's pretty hot up here today.
Terrible.
So convenience, right? That's the traditional reason why people would change situs. Other reasons why you might want to change situs is something that we call the alluring appeal of another state's laws. You will hear various states have different laws that apply to trusts that you might like better than your current states, or you might be able to do things that are easier in a new state than you can currently do, or you can do it without court approval in state X, but state Y doesn't let you do that. And so you might want to change the situs so you can try to take advantage of those laws or use those laws. And then another reason is tax-driven. Income taxes, as I mentioned earlier, trusts pay are their own taxpayers, and states tax trusts what they call as a resident trust, just like individuals can be residents, right? You're a resident of Pennsylvania, you're going to pay income tax to Pennsylvania. Well, trusts are the same thing. They pay tax if they are a resident trust, but each state determines what makes a trust a resident trust differently. Some states, like Pennsylvania, New Jersey, determine it based on the person who created the trust. Were they a Pennsylvania or New Jersey resident? If the answer is yes, then the trust is going to be a Pennsylvania resident trust. Other states like California will look to where the trustees are. And if you have a trustee in that state, it's going to be taxed as a resident trust. Other states will look to where the beneficiaries are. Now, there are some questions about the legality or the constitutionality of that, whether it's constitutional to tax based on the resident of beneficiaries. That went all the way up to the United States Supreme Court recently. But each state taxes trusts differently, and depending, again, for constitutional reasons, if you have or don't have certain contacts with the state, there are instances where you can, if you change situs, stop paying taxes to the state that you were in before. And depending on the laws of the new state, they may not tax it either, so you can be in a situation where you're not paying income tax to a state at all, which Pennsylvania's income tax rate is 3.07%. You can easily do the math to say, well, if we had changed situs, we might have been able to avoid that tax. As long as there's no other connection to Pennsylvania, we could have saved that tax. And you can calculate what the damages are.
That can be a big number.
Yep.
So are there circumstances where one could be paying income tax in multiple states based on where the trust is situs?
Yes, there are. So think about, let's talk about a situation where it's Pennsylvania again, right? Pennsylvania is going to look to where the creator of the trust was living. Pennsylvania creator, settlor, it's a Pennsylvania resident trust. You're going to pay tax as a resident trust here. But let's say you also have a California trustee. California is going to tax it as a resident trust based on the presence of that California trustee. Now, if you have two trustees, one of whom is a California resident, one of whom is, for example, a Pennsylvania resident, the way that California does it is they do it proportionately. They say, well, if only half of your trustees were California residents, we're going to treat half of it as a resident trust, as long as you don't have any beneficiaries that live in California, because that complicates things. So you could end up with a situation where you are paying taxes in multiple states, or where you should be paying taxes in multiple states because of certain connections, either because where the beneficiaries are, where the trust is administered, where the trustees are, which is not always the same thing as where the trust is administered, or where the settlor was created. So you can see, or where the settlor created the trust, rather. So there are situations where you could end up paying tax in multiple states, and that's a big concern when you change situs, is having to, you don't want to cause a problem that's worse than what you have already. So if you're saying, well, right now we're paying 3.07%, but if we change the situs to California, we can eliminate the Pennsylvania income tax at 3.07%. But if you have California trustees, it's a California resident trust, you're paying tax there at depending on what the rates, depending on what the income you're realizing in the trust, could be 10%. So you've gone from 3.07% to 10%. What have you solved
backwards.
for? Yeah, you're going backwards.
So I'm trying to understand, on an annual basis, the tax filing for a trust must include then questions about where the trustees are living, where the beneficiaries are living, whether they've moved. Is there an annual kind of audit that takes place? And this is more of a tax question, I think, but
No, I mean, I'm thinking about the Pennsylvania income tax return. I think really only lists. I mean, if there's been a change of trustees, you do reflect the change, but you don't need to submit. A lot of times, trust income tax returns will just list one of the trustees. They don't even list all of the trustees. In some respects, I guess it's an honor system, but you are signing these returns under penalty of perjury.
Sure.
So if even if you're not listing all of the trustees, you still have the responsibility to file your income tax returns accurately.
Interesting. Okay.
But other states, well, I should also say though, Steve, to your question, I mean, California does ask.
Oh.
It's specific to the state. There's not a uniform tax return. So California does say, how many California trustees how many trustees are there? How many California trustees are there? And that's how they determine how much of that income is taxable as a California resident trust, because if you have 5 trustees, 2 of them are California residents, Like you actually fill all that in, and then they say, okay, well, 2/5 is going to be taxed. And they also ask questions about certain types of beneficiaries, and it's the same kind of question. How many beneficiaries are there? How many of them are California residents? And so they may assess additional tax based on that.
Does all of this fall on the trustee in terms of where this is situs, or you and your team would work with the trustee to assess where the most efficient way to structure or situs a trust should be?
Well, and so, Mark, you're getting into kind of the duties of a trustee. I mean, you don't need to be an expert. A trustee doesn't need to be an expert in trust and estates law and the tax laws of all 50 states to be a trustee. With that said, I mean, trustees do have fiduciary duties to administer the trusts in the best interests of the beneficiaries. And that is part of that duty. That could include, are we administering the trust where we should be? Does that mean that if I'm a trustee in Pennsylvania and I want, and it would be, we would save tax if we changed the situs to a different state? In order for Pennsylvania to stop taxing the trust as a resident trust, there can't be any, Pennsylvania takes the position, there can't be any Pennsylvania trustees. So I might have to resign. So do I have a duty to tell my beneficiaries that maybe I shouldn't be serving as trustee anymore because we could save you taxes if you change the situs to another jurisdiction? Maybe so. But as a trustee, you have a duty that's beyond your own self-interest. You have this fiduciary duty. And so you don't need to be an expert in this, but that's why you need to end up seeking counsel. And one other thing to your question about these duties is there are states, there's something called the Uniform Trust Code that about 38 states have adopted some form of this. And in their change of situs statute, the default provision that some states have adopted, others have not, Pennsylvania has not adopted this, but it says a trustee is under a continuing duty to basically administer the trust in the situs, or they call it principal place of administration, that's most appropriate for the beneficiaries and the trust and all of that. So and Pennsylvania did not adopt that because of the concern that you would constantly have to change situs all the time or seek better jurisdictions or what could be perceived as a better jurisdiction because of this provision. So Pennsylvania hasn't adopted it, but a lot of states have.
Appropriateness. That's vague. What is appropriate? Are you going back to the three drivers in terms of where a trust should be situs to?
That's it. It's a good question, right? And there's no real guidance on that. I'm not aware of case law where that's been kind of challenged. With that said, the easiest one to do could be taxes. Again, if you can say, if you had changed this, we could have saved all of these taxes. It's easy to show what the damages could have been.
Do we want to talk about what some of the potential risks or downsides of moving a trust would be? I mean, I'm sure there's a decision process that you go through, and part of that is if we do this, here's some of the risks, here are some of the downsides.
So one of the risks that Mark, you were kind of asking about is you don't want to go from a situation where you're maybe trying to avoid taxes and then end up paying more taxes because of the laws of the new state that you've moved to. All of a sudden you've now caused the trust to become a resident trust in another state. So that's something that you always want to look for when you are changing a situs is what are the tax consequences of us changing, both by leaving but going into the new state. So that's one of the concerns. There are always concerns having to deal when you're making changes to trusts, especially to the extent that these trusts are exempt from the generation skipping transfer tax, that when you make changes to a trust, including by changing situs, that you're not doing something that could cause the trust to lose its GST exempt status. And that's maybe a discussion for another day. Suffice it to say that the consequence of screwing that up could be significant. I mean, we're talking 40% taxes if you mess it up. A lot of times it's easy, or with a little bit of forethought, you can avoid that issue. But this is the type of change to a trust that maybe you wouldn't think could implicate generation skipping transfer tax, but it ends up doing that. And then there are questions about what laws apply when you do change, and that's something that you really want to spell out when you're doing a change of situs, but then also making sure that loose ends are buttoned up from the state that you're leaving so that someone couldn't say, well, even though we've changed situs, the court of the old situs might still be able, I might still want to try and file in the court of the old situs, because whether a court has jurisdiction over a trust is not exclusive to where the situs is. There can be hooks that a court could still try to exercise jurisdiction over the trust. So those are things that you want to think about when you're changing situs, is how do we wrap everything up so that we have a clean break from one jurisdiction to another and that everyone's on the same page so you're not having questions later or issues later. And I think that designation of jurisdiction and designation of governing law can really go a long way to addressing that.
Let's dive a little into the governance of a trust. Once moved, who is it, the original jurisdiction of the trust or the new jurisdiction?
So there are, as far as governing law in the context of trust, there are kind of three types of governing law. There's validity, there's construction, and there's administration. Now, if you might ask me to give, what validity is was the trust created appropriately? Was the trust valid when you created it?
Based on the laws.
Based on the
that
laws
time
at that
and the
information
time. And the okay.
Exactly, in the original jurisdiction. So even if you change the situs, they're still going to, even if you change the situs again, we'll go from Pennsylvania to Delaware, okay? Delaware, even if you change the situs to Delaware, Delaware is still going to look to if the trust was validly created under Pennsylvania law, because that's when the trust was created.
Yep.
That's usually not going to change, even if you change situs. Construction is how do you interpret various terms or provisions, such as what does it mean when you say distribute the assets per stirpes? One state might interpret that provision differently than another. And that's going to be governed, again, by the law of the original jurisdiction. Other questions, really this is probably more validity, or things like the rule against perpetuities, which is how long can a trust last?
Now you're talking Delaware.
Now you're talking Delaware.
Yeah.
And then there's administration, which are things like, what's a reasonable fee for a trustee to charge? If a trustee can no longer serve, and the trust document doesn't say how you appoint a successor, how do you do that? Mm-hmm. That's going to be what would be considered administrative law. Now, there are some times where those lines blur. There's something called a unitrust conversion. Basically, trusts, if it can distribute income, which is interest and dividends, some states will allow you to convert that trust to a unitrust. Rather than income being interest and dividends, it's a percentage of the total value of the trust. 4% a lot of states will use. Is that administrative? Is that construction? It's a little unclear. So that is, there are times where those lines are blurred. So when you change the situs of a trust, if the document itself doesn't say otherwise, in general, validity and construction is going to remain in the state that it was originally. But the law governing administration is going to be the new jurisdiction. But what I tend to do when I do change of situs is to spell it out. Don't just rely on what the default provisions. It's everyone agrees that, for example, Pennsylvania law is going to apply to validity and construction, but administrative law is going to be governed by the law of the new jurisdiction, so that there isn't a question later as to which laws apply. And sometimes what you'll see in especially old documents is sometimes you'll see a trustee can change the size of the trust, but the document itself will say, but the laws governing validity, construction, and administration will be governed by the laws of the original jurisdiction. So unless you go through and modify the trust further, there's an argument that you don't get. If you wanted the administrative laws of a new jurisdiction to apply, there's an argument that you don't get that unless you modify the trust. So those are kind of some of the things you need to think about. And there was a whole Delaware case that kind of examined that issue. about what happens if you change the situs of the trust, but don't explicitly address the governing law in the document.
When you're drafting a trust, do you deliberately put language into the trust that gives you some flexibility to change the situs in the future? Is that routine? Is that part of the kind of the base?
We do.
Yeah.
And we see it more and more in other documents, but our documents, we do include that the trustee will have the ability to change the situs. We also give the trustee the ability to change not just the administrative laws, but laws governing validity and construction, subject to certain limitations, because again, you don't want to cause additional problems such as tax problems or violate, for example, the rule against perpetuities. But we do give the trustee a lot of flexibility to change the situs and address issues regarding governing law as much as possible in an attempt to give as much flexibility without having to go to court or rely on statutory provisions that could end up being more expensive or more burdensome.
Another off-script question, but I'm curious. Mark and I often talk about why do different states have different rules and laws? Is it driven by tax revenue, or is it driven, if there's not extra tax revenue, what's the driving force of a state to make the provisions more favorable?
So some of it's business, and now whose business, right? You might say, well, we have trust companies that want to encourage you to come into a particular state. And if we can entice you with laws that state has that maybe other states don't have, our neighbor to the south here, Delaware, will tout something called a silent trust, that you can create a trust where maybe beneficiaries don't even need to know about the trust. We'll set aside, this is again a topic for another day, whether as a Pennsylvania resident you can actually make a trust a silent trust even by changing the situs. But that is something that might be attractive to certain types of people. And if your state has that and other states don't, setting aside whether that would be effective, that's going to drive you to maybe try and create a trust or move a trust to that state. And oh, by the way, you need to have some connection to that state. How do you do that? If you don't have any family who lives in Delaware,
you got to be creative.
You need to hire somebody. Yeah. So it's that. I mean, it's marketing, and so it's not necessarily going to be tax driven, because a lot of times what's touted is if you move to this state, you're not going to pay taxes. So I'm not aware really where people are saying, come to our state, we have great laws, but you'll pay us more. Now, where you do end up paying sometimes is courts. Sometimes the filing fees end up being high. And I mean, let's face it, it's the lawyers who make money, right? So there are certain states that have laws that might end up being very attractive. Whether you can take advantage of those laws if you don't live there initially is not always clear. Whether you can do the things that you want to do in the state that you want to go to, those are things that you need to make sure you can do beforehand. Mm-hmm. So it's always good to have good representation and ask good questions before you actually change the situs to make sure you know what you're getting into. And you're not surprised later. It's like, oh, I didn't know now that every time I want to do something with my trust, it's going to require an agreement, and it's going to be $10,000 every time I want to do something, when I didn't have to do that before.
The issue from a few years back, Brad, where Delaware passed a law that if a trust owns a private placement life insurance product, that the state of Delaware was going to have, at that time, a reduced state premium tax, a significantly reduced state premium tax. Mm-hmm. And so everyone scratched their head a little bit and said, why would Delaware allow that? Well, if the business was then presented to Delaware-based trust companies to then own these policies to save money ultimately on the internal expenses, the idea was it was going to generate other, not necessarily tax revenue. In fact, it was decreasing tax revenue, but other revenue was, somebody must have done the analysis, the other revenue was going to be greater than the loss in the tax revenue. So that's an example that's in our world with the insurance products.
Yeah, and I'm sure that some of those are the same kinds of considerations. Whether they've played out the way that the projections said they would, that's beyond my pay grade.
Let's move to some real life case studies or some experiences that you've had. Do you want to share with us some stories?
Yeah, absolutely. I will try to avoid using any identifying characteristics, unfortunately, even though sometimes they're pretty good. But I can think of, there was one matter where a trust had, and this is not uncommon. This happened to be a Pennsylvania trust where the situs was changed to another jurisdiction with the consent of all of the beneficiaries. And in the agreement, they said, even though we're changing the situs to this other jurisdiction, Pennsylvania law is still going to govern the validity, construction, and administration. You can do that. You can say, even though Texas is going to be the jurisdiction, it's going to apply Pennsylvania law. You can do that. In this matter, several years later, the beneficiary passed away, and there was some litigation that occurred after the beneficiary's death regarding certain powers that the beneficiary may have had or didn't have, or exercised properly or didn't exercise properly. And the litigation that was going on was all occurring under the laws of the new jurisdiction. And they're looking at these issues under the laws of the new jurisdiction. And I want to say maybe a year and a half, 2 years later, someone kind of said, oh, wait a second. Well, we've got this agreement here that said the new jurisdiction's laws don't apply. It's Pennsylvania law applies. And that's how we ended up getting involved, because the trustee said, well, we need you to advise us on the Pennsylvania aspects, which were different than the laws of the new jurisdiction. And they had to tell the court, by the way, Judge, even though you've been applying the laws of the jurisdiction you're familiar with, oops, it's actually Pennsylvania law. So that's a cautionary tale. I'll give another cautionary tale, which, remember, I had said earlier that designation of situs doesn't necessarily mean which court has jurisdiction. It often means that if you designate Pennsylvania law as the situs, Pennsylvania will have jurisdiction over the trust. But that doesn't mean that other states might not be able to assert jurisdiction over the trust. And what's happened in this matter is there was an agreement that everyone said Pennsylvania law, Pennsylvania is the situs, and Pennsylvania court has jurisdiction over this trust. But one of the beneficiaries lived in a different jurisdiction, and there was some litigation that was initiated concerning the trust in that other jurisdiction. And now there's a question. This agreement didn't say, for example, Pennsylvania had exclusive jurisdiction over the trust. And now there's a fight over which court has jurisdiction to resolve this issue. And really, you have a case where two courts probably have jurisdiction to resolve the issue, and which one's the better one? Those are things that perhaps, had some of these issues been addressed in an agreement when everyone is quote unquote happy, that you could have maybe avoided a lot of the litigation that's going on now, which is you have two courts that might be able to assert jurisdiction. Now you're fighting over it. You're hiring lawyers in two different jurisdictions. And as you can imagine, it's very costly and very time-consuming and frustrating and uncertain. Whereas if you'd put in an agreement, any questions regarding the administration of this trust or distributions from this trust, it's all going to be handled in Pennsylvania no matter what. Maybe you've avoided those issues.
When a client comes to you to draft a trust, is there specific fact pattern or a couple fact patterns or issues that become evident quickly that encourage you to pick a particular trust situs immediately versus the one that's, in the state that we're sitting right now?
So it will depend. If my client is a Pennsylvania resident, there's probably not too much we can do while they still live in Pennsylvania. Now, I might advise them, depending on what other connections they have or don't have to Pennsylvania, that in the future you might be able to change it. Okay. But a lot of times, if it's an existing client, most of the time they are, I'm licensed to practice in Pennsylvania, I'm licensed to practice in New Jersey. We have other attorneys here who are licensed to practice in other jurisdictions like Florida. But if it's a Pennsylvania resident coming to me, there's not much we can do now. What I will do, though, is if they want to name their kids as trustees of a trust, for example, and one of their kids is a California resident, I need to know where their children live or whoever the trustees are, because then I can inform them and say, you can have your kid serve as trustee, but they live in California. There's going to be more tax. And they might make the decision that even though it's going to result in more tax, I still want my child to be the trustee. That's fine. We're not here to just save taxes blindly, but what we do want to do is make sure we have a client who can make an informed decision and say, you can do this, but you need to know what the consequences are. Right. And then they weigh the pros and cons. But I can't do that unless I have the information, like where are the assets located? What type of assets are they? Are they closely held business? It's a closely held business interest, because that's going to affect where's the quote business situs of that asset. Where are the trustees living? Where are the beneficiaries living? And then you can help advise the creator of the
and you're
trust.
Just going down the decision tree.
Yep.
Yes,
exactly.
no, here, there. Okay.
Yep. To reiterate what Steve was saying, we know very little in terms of trust situs, though it's extremely important. But
hopefully you know more now.
We do.
Absolutely
and
do. Thank you.
We really appreciate you taking
Sure.
the time out of your day. And most of our policies when dealing with estate planning are trust-owned. So we appreciate everything you shared. But when you're not managing trust situs or moving their jurisdiction, what if you didn't have to sleep, what would you do with the extra time?
Probably I would catch up on my work.
No, that's not a valid answer. Yeah.
If I didn't have to sleep, what would I do with the extra time? I would definitely read more and catch up on the shows that I say I'll watch and never do.
That's a commitment.
It is. I don't sleep all that much anyway, but I'll have an extra 5 or 6 hours a day to do it. Trying to think what hobbies I would take up. I bike, so maybe I'd bike more.
There you go.
Although if I'm not sleeping, it's probably in the middle of the night, right?
Yeah.
So that's not all that safe.
Yeah,
I have Peloton.
Good reflectors, Peloton.
There you go. I'll just do the Peloton more.
All right, exercise more. I
yes.
like it. Well, Brad, thank you for your time. Brad
Thank you for having
Terebelo, partner at Heckscher, Teillon, Terrill, and Sager.
Heckscher, Teillon, Terrill, and Sager.
Heckscher, Teillon, Terrill.
Terrill.
Heckscher, Teillon, Terrill. Heckscher, Taylor.
Nope.
Hold on.
I hope you keep this in.
The material and opinions voiced are for general information only and are not intended to provide specific advice or recommendations for any individual. To determine what is appropriate for you, please contact a member of our team. Brad Terebelo, partner at Heckscher, Teillon, Terrill, and Sager.